Okay, I think we can. I think we can start. So after these two very fascinating and thought-provoking roundtables, where we discuss some of the crucial issues in thinking about regulation, especially how it should be dealt with, how it should be structured, where should it come from, we will now move on to three panels. This is the first of three panels in which we will discuss specific issues that could or would be addressed in regulation. This first panel, which I have the honor of moderating, will be about structural issues. So basically, when thinking about regulation of DAOs, especially some of these issues, especially if that regulation comes from the legislator, for instance, we have to think about three major issues. We have to think about three major issues when structuring that. The first is the great question, the crucial question, which is, should DAOs in any regulation scenario be accorded legal personality? Should they be considered persons separate from their members? For that, and we have Florian Möslein from the Philipps-Universität in Marburg in Germany. Florian, for those who don't know him, is one of the most prominent voices in Germany about Web3, blockchain, and their impact in company law, financial law, and securities law. So he's a big authority on the issue, and I'm pretty sure he will give us a very thought-provoking presentation on whether DAOs or not should have legal personality. Then we have Bian Minat, also from Philipps-Universität Marburg. He's an attorney. He works at Luxor right now, and he has published a groundbreaking thesis in Germany as well about DAOs and their relationship with company law. So he's also a very renowned and well-respected name on this issue, especially in Germany. Unfortunately, this panel has been plagued by some changes. As you can see, this is not Silke Elrifai. This is Christopher Wright. Silke unfortunately had some health issues that made it impossible for her to participate. But we have the stop queue replacement, which was suggested by Silke herself to tell us about DAO governance and voting process. So basically, how any regulation should, if it should address at all, how DAOs govern themselves. Unfortunately, and also another last-minute issue, Morshad Manan, who would, from the European University Institute of Florence, would talk to us about DAOs as contracting parties, had also a health and family emergency at the last minute, so we can't make it. But I think we'll have here a very nice panel in which we'll discuss the crucial issues of legal personality. Also, and I forgot to mention, Bian will tell us if DAOs should have limited liability or not, and how that should be construed or configured in case of regulation. And finally, as I mentioned, Chris is a barrister. Chris is a crypto law expert and also a philosopher about the implications between blockchain law and technology. And he will talk us about DAO governance and voting process. So, without further ado, I know there were some sound issues in the first panel. We'll try to speak more clearly to the microphone, but please, for the people at home, please understand that this microphone is so high tech and so good that it catches a lot of sound around the room. So please understand, and we thank you for your understanding. We'll try to provide the best experience that we can. So first of all, we'll start then with Florian Möslein. So Florian, the floor is yours. Thank you.
Thank you so much, Antonio. My micro is much more low-tech than yours, so I hope you can understand me in spite of that or because of that. Thank you so much, Antonio, for your much too kind and really exaggerated introduction. I'm really happy to be with you, even though not in person, but at least digitally. Now, the question that you have asked me to answer is a tricky one, but it's also a core and very fundamental question. Is legal personality for DAOs really necessary? I could make it very brief and give a typical lawyer's answer. Well, it depends. But maybe you want me to explain this answer in some more detail, and I'm more than happy to do so. In order to open this panel, at the same time, I can really build on much of those thoughtful and very deep comments that have been given earlier this morning. And then basically it will be a kind of wrap up of those comments and remarks of the previous speakers. Now, let me start with tools actually from the US. One concerns SushiSwap. You might have read the news about SushiSwap, a maker of an Ethereum-based decentralized exchange, the SushiSwap as such, and the Sushi DAO, which is behind that that exchange, received a subpoena from the US American SEC regarding this DAO. So this was basically the first time that, or one of the first times that a DAO was really addressed by a public authority. A similar case concerns UkiDAO, where another public authority, another supervisory authority in the US, namely CFTC, began a lawsuit against this DAO, which is a non-custodial crypto margin DeFi trading platform. So both cases are in some respects similar, even though different public authorities and different DAOs were concerned. In both cases, however, the question of legal personality comes up in a somewhat different way than it usually was discussed. The usual discussion was about civil liability, about legal personality and liability of the members. But now we are in a supervisory context. The question really is whether DAOs are the right addressees of public law measures here. Now, let me come back to these two examples while I'm talking. The structure of my talk looks much more sophisticated than it really is. I first will comment very briefly on legal personality and on the legal status of DAOs. I will then go and dive more deeply into DAOs in the DeFi context, which is, as the two examples show, the most prominent and the most relevant context for the question of legal personality. And at the end, I will try to conclude and try to give a somewhat more precise answer to the initial question. Now, legal personality, of course, is the idea that the legal system contributes rights and obligations to a person, and it is the capacity to be the bearer of rights and obligations. For instance, the capacity to own assets, or the capacity in a more public law context, the capacity to be the addressee of a license or of an act of the supervisory authority. Natural persons, of course, can be bearer of rights and obligations and are bearer of rights and obligations with their birth. But for organizations, for entities, the question is much more sophisticated because these entities require legal recognition in order to have this capacity. Now, if we look at DAOs, we need to distinguish between two different situations that have already been mentioned this morning. The first and more natural situation is a DAO without any legal wrapper. And even in this situation, a DAO can be a bearer of some rights and obligations. At least it can be treated as a sort of general partnership, depending on the national legislation. But the consequence is usually that all partners will be fully liable, and partners in this context are the governance token holders. And along these lines, US courts have already taken the decision that the participation in a governance vote is seen as a kind of proof for membership in a DAO. So once you raise your voice as a governance token holder, you can be made liable under the traditional partnership law. The assets of the DAO do not belong to the DAO itself, to the governance token holders, but the backside of that is their personal liability. Now, let me stress again that much depends on the national jurisdiction. For instance, the question whether the DAO itself can be a party to a lawsuit as a partnership, and also the question how many rights and obligations it can really raise. Now, the second different situation is that of a DAO that has a legal wrapper. And again, we have to distinguish between traditional legal wrappers, so a traditional form of company or association, like a LLC, for instance, that lawyers build around a DAO, or more specific new corporate forms like the Wyoming DAO LLC or the Liechtenstein Foundation, which are tailored specifically to DAOs. There are not many jurisdictions around the world that have tailored such legal wrappers. So the more frequent case will be a traditional wrapper. Now, what are the legal consequences of such legal wrapper, be it a traditional one or a specific one? The most important consequence is, of course, limited liability. As opposed to the partners of a general partnership, in this case, it is the DAO that is liable, not its members. The DAO holds its own assets. It is the owner of the assets. And also important, there are clear rules and competences in case of legal action. So who is able to represent the DAO before the courts and so forth. Now, if we look at the more specific case of DAOs in financial markets, it is interesting to look at the MiCA regulation, which has, by the way, been passed by the European Parliament just a few minutes ago. The message just popped up on my screen. And I think the provisions that I'm referring to have not changed in the last minute. So one provision that I want to draw your attention to is recital 12A, where the MiCA refers not only to natural and legal persons, but also to other undertakings. So obviously, it refers not only to legally wrapped DAOs, but also to DAOs that are qualified as a general partnership under national law. Now, there are two further recitals or two further provisions of the MiCA that are similar. Recital 50 refers to undertakings that are not legal person, but commercial partnerships. So that makes it even clearer that also these other DAOs fall under the MiCA regulation. Article 53, paragraph 1 of the MiCA that refers to the level of protection for third parties' interests and to an equivalent level of prudential supervision, regardless, more or less, or appropriate to their legal form, all that shows that the draftsmen and women of the MiCA regulation clearly thought about DAOs that are treated not as legal persons, but as partnerships. Now, how does that correspond and fit with the economic functions of DAOs in the DeFi area? What do DAOs do? Well, they offer financial services, brokerages, exchanges, similar to banks, and the core instrument, of course, are smart contracts. Examples are platform borrowing and lending, or decentralized exchanges, stablecoins, and so forth. So the promise of DAOs is really in alternative financial architecture without intermediaries. Disintermediation and decentralization are topics and keywords, buzzwords that have already been mentioned this morning. Just to give you some examples, MakerDAO, the Sushi Swap that I have already mentioned, the Uki DAO that I've also mentioned, and Compound DAO and Yearn Finance that have different functions, but fitting into the general framework that I have just described. Now, it is important not only to look at the economic function of the DAO on these markets, but also to look at the internal governance of DAOs, on the governance structure of DAOs. How can the product specifics be changed? How can risk questions be solved? I think the qualification, the legal qualification of DAOs crucially depends on these governance structures. And I want to refer your attention to a very interesting article that analyzes these governance structures of various DAOs that you see on this slide. Now, in order to not to talk too long, but to draw some conclusion, I try to answer the initial question: is legal personality needed? Well, there are several arguments brought forward against legal personality. One, and a very important one, is that the core concept of decentralization somehow speaks against legal personality, because the whole idea is that law is replaced by technological code, and that speaks against any legal qualification of DAOs. Moreover, it is difficult to establish competences and representatives for DAOs because they are decentralized. At the same time, these attributions are a necessary precondition for legal personality. Then any requirement to register legal entities is somehow contrary to the idea of DeFi and the idea of DAOs. Those are really the three core arguments. Further arguments are, for instance, named in the NACBA report on DAOs of 2022. A core question is, of course, the liability issue, and it is interesting to look at this US provision that you see on the slide here. In case of any infringement of financial markets regulation, this is the basis to make both governance token holders and the DAO liable. So that is really something that might even be more important than the question of legal personality. If you have a rule that makes the governance token holders liable anyway, the question of legal personality loses much of its relevance. In terms of not liability but licensing, there are, of course, jurisdictions where DAOs have at least some degree of legal personality, because some jurisdictions allow general partnerships to acquire the license or to get a license. Other jurisdictions require every single partner to obtain a separate license, and that makes an obvious difference in terms of practicality of getting a license. Now, in that respect, a clear rule on legal personality of DAOs would allow to obtain licenses. Maybe you do not even need full legal personality in every sense of the word, but at least with regard to licensing, I think some degree of legal personality would be at least very helpful, if not necessary. Now, my last slide comes back to the Uki case. Would Uki have been happier if it had a legal personality? Well, it did not have a legal wrapper, but it was thought to be able to be party to a lawsuit, even as an unincorporated association. Possible infringements of financial markets were possible even without a legal wrapper. Liability of both the association and the governance token holders were based on this finding. There was, however, on the other hand, no clear competence within the Orchid DAO, so it could not really defend itself, and a regulation could make it factually impossible to obtain a license as a non-wrapped DAO. So it was really difficult because, on the one hand, Uki was declared liable and its token holders as well, but on the other hand, it was neither able to defend itself nor to legitimize itself by acquiring a license. With established legal personality, on the other hand, UkiDAO would have had clear competence rules for lawsuits. The liability of governance token holders would not necessarily have been excluded, but potentially. And the UkiDAO, maybe most importantly, could have applied for a license as a commodities exchange, and that would have solved its core problem. Thank you for your attention. That was my input.